Good day, all. Now I'm giving exam topics questions in three videos regarding media law. The questions are mentioned here. Now I will directly go into the topics. Mass media versus traditional media. Let us see the concept of media. Media is generally the agency for interpersonal communication. There are two kinds of communication. Personal communication mechanisms is one kind of media, while the other is the print and electronic media. They are also classified as traditional media and modern media. Personal media. The personal media or personal communication mechanisms are essential elements of mass media. These mechanisms include several aspects of social media. They are advocacy, legislative advocacy, social justice lobbying, public international litigation, social action, agitation, demonstration, etc. Mechanical media, print media and electronic media. Print media means newspapers, pamphlets, books, photographs, photo exhibitions, etc. Electronic media means radio, films, documentaries, television. The purpose of communication and media. Media provides a vehicle for communication. Communication in the world of men and animals is an ever continuing process on all the time. It is as necessary to human, animal, and vegetable existence as life itself. Halt in communication and the life processes wither and die. The need for communication is as basic as the hunger for food and drink. Interaction, interchange, a sharing, and commonness are various phases of communication. The word communication is derived from the Latin communis, which means common. Dennis McQuill says that the human communication is the sending from one person to another of meaningful messages. Communication encompasses all forms of expression to serve the purpose of mutual understanding. The communication is the process by which information is transmitted between individuals and or organizations so that an understanding response results. The important elements of communication are the sender is who, the message is what, and the feedback is effect. Mass communication. The mass media instruments are founded on the idea of mass production and mass distribution, which in turn results in mass media culture. Interaction between living beings and environments in a sociological group is communication. Mass communication is generally identified with the modern mass media like press, radio, television, cinema, video, and now the internet. As generally interpreted, the mass media are the press, cinema, radio, and television. But books, magazines, pamphlets, and direct mail literature and posters are also need to be included under the label as their reach extends to vast heterogeneous masses. Mass communication has now become an independent academic discipline and can be considered as an important aspect of modern man's study of his civilization. This discipline has a bearing on sociology, anthropology, economics, politics, literature, the performing arts, and the electronic media. The mass in mass media has kept stretching its meaning with increasing reach of each modern inventive tools of media like television and internet. Traditional media. Even today, you will find villages where there is no proper electricity. People in such places might not be able to view television or access the internet. Illiterate people will not be able to read newspapers or magazines. However, this does not mean that they do not communicate. They have also developed different ways of communication depending upon the local language and culture. Traditional community media like the Kirtana and by the whole treasure house of folk song, folk dance and folk theatre, puppet show, Surabhi theatre, Harikatha, Burrakatha, Yakshaganam and public meeting, religious fairs like Ganapati Navaratri, Devi Navaratri are organs of the mass media. Traditional media versus mass media. Traditional media is non-technological in nature, flexible in nature, but culturally rigid. Less expensive medium. Messages are presented. Reach is limited. Mass media, technological in nature, flexible but enjoys cultural freedom. Expensive medium, which needs high monetary investment. Messages are transmitted or broadcast before a live audience. reaches out to large number of people. Traditional media in present era. In traditional media, forms like storytelling, theater, dance, singing, etc. Your body is your media. You can create messages and communicate without using any form of mass media. You can create your own media. A singer with a creative thought and awareness of issues and loud vocal strength can turn himself into a powerful people's traditional medium. On the other hand, for the electronic media, you need a certain style, dress code, diction, literacy, etc. They generally do not involve active audience participation. But traditional media is inclusive in nature. They are highly intimate and local specific and deeply connected to one's own lives. Coming to the next topic, pre-censorship of films. All the sources of entertainment, such as movies, press, social media, are provided with constitutional validity under Article 91A that states the freedom of speech and expression for all the citizens in the country. There are no limitations to this fundamental right except any reasonable restrictions placed by the government authority for reasons enumerated in Article 19(2) of Constitution. Cinema has traditionally served as a vehicle for depicting social issues on display in a broader context. As a result, it served as both an inspiration and a moment for introspection. Coming to censorship. Censorship is a term generally used to connote the process of restricting the access of ideas and information in apprehension that it may disturb the public peace. The definition of censorship lies in the example of a man expressing his opinion, thoughts, or ideas orally or in writing. The opinions are such that causes disturbances of public morality, promotes obscenity, and hampers peace. The censorship is imposed by a public authority to restrict a man from the expression of such opinions that have the ability to cause negative consequences. In 1948, the Board of Film Censors in Bombay and Madras released a so-called production code which provided motion picture producers with guidelines on how to make feature films. This was the first significant reform in Indian film censorship procedures following independence. The code was ostensibly created to ensure that cinema performs its rightful role in the development of a healthy public culture. The Bombay Home Minister recommended that film scripts be presented to censorship agencies prior to the start of movie productions. Following that, many legal changes were made to the then current administrative structure and nature of cinema censorship, which had been formed under the terms of 1918 Cinematograph Act, which was passed in 1919. After the Cinematograph Amendment Act of 1949, two new censorship certificate classifications were formed. A certification that limited cinema viewing to adults over the age of 18, and U certification that indicated the picture was appropriate for unrestrained public display. In India, this was the first time a system of film censorship based on audience age was employed. The Cinematograph Second Amendment Act of 1949 was the last piece of legislation to execute the recommendation of the Indian Cinematograph Commission of 1927 to 28 for the establishment of a central board of film. Coming to rule of law, the imposition of censorship follows the doctrine of rule of law, which is the basis of determining the constitutional validity of any administrative action. The censorship falls within the right to freedom of speech and expression. Due to lack of any clarity over medium of communication of ideas in the clause of 19(1)(a), the practice of censoring movies to remove any objectionable material by censor board has been followed in India. It is to make the movie suitable for target audience. The viewership is based on the certificate issued to every movie prescribing the audience that can watch the movie. Coming to legislation, there are certain legislations in India dealing with censorship in movies to reach the satisfactory level of public morality or other reasonable restrictions. The competent authority is entrusted with the responsibility to watch the movie and make suitable suggestions to the makers before issuing the acceptance certificate to release the movie. The Cinematograph Act 1952 says the legislation exclusively deals with censorship of movies in India with respect to certain rules and regulations established by law. The certification, censor board establishment, and scope of such board is provided in this legislation. Establishment of board. Section 3 of the Act states that the central government has the authority to constitute a board of film certification consisting of a chairman and other members. The board is established to watch the pre-released movies and sanction them suitable for public exhibition. Examination of films. Section 4 of the Act states the procedure to examine the films by the board before the release. The film is sanctioned for public exhibition after the complete examination process is achieved. Coming to the famous case K.A. Abbas versus Union of India in 1970. The facts are the film questioned the link between basic rights and the Cinematograph Act 1952, testing the censorship company's political liberalist arguments and causing a shockwave in the court. Images showing Bombay's red light area posed the most difficult for censorship board and judges to deal with. The government has chosen to award a U rating as part of the certification process if the portions shot in the red light area were removed from the movie. After a complaint, the court recommended a U certification if several red light district images depicting unethical exploitation, corporate exploitation, and prostitution were removed. The petitioner sought and the court granted permission to modify his complaint. He further argued that pre-censorship had no legitimate aim because the law's provisions were imprecise, capricious, and indefinitely granted to various agencies. Supreme Court observation and the judgment. In this landmark case of K. Abbas versus Union of India, in which Supreme Court mentioned that courts do not recognize the difference between pre-censorship and witnessed that both are controlled by the benchmark of reasonable restrictions in Article 19(1) of the Constitution of India. The judges in this case rationalized that pre-censorship of movies is lawfully justified on the grounds of following reasons. Pre-censorship or prior restriction is simply one component of censorship in general. Censorship in the interests of decency and morality, etc., is constitutionally sound in India under Article 19(2) of Constitution. Consequently, pre-censorship is also constitutionally valid. Bandit Queen case. The Supreme Court, while dealing with this case, once again upheld the freedom of speech and expression under Article 19(1) through cinematograph. The Supreme Court observed that a film cannot be restricted simply because the content is obscene, indecent, and immoral. The abusive language and or nudity in the movie was to further the case regarding the depiction of the reality of the life story of Pulan Devi. The movie was provided with a certification under Section 5B with restricted viewership for adults only. Coming to the next topic, permissible exemptions from disclosure under the Right to Information Act. Introduction. Though the right to information was uniformly recognized by the court in series of cases as an aspect of freedom of speech and expression, and even it is extended to right to life, it was finally incorporated in the Right to Information Act 2005 and given full mechanism for its realization. In the long history of RTI Act 2005 in India, there have been varied challenges to beat. Since the British times, there are several laws that prohibited implementation of right to information. RTI Act 2005. Right to Information Act 2005 has been probably the most discussed law of the recent times and also given much more power to the people than any other law. Its aim is to provide for setting out the practical regime of right to information for citizens to secure access to information under the control of public authorities in order to promote transparency and accountability in the working of every public authority. The same has been hailed as the win of a democracy over the hurdles created by the archaic system of rules set in place by the erstwhile rulers of the India. No paper which goes into any aspect of the Right to Information Act would be complete without the acknowledging the effects of the Mazdoor Kishan Shakti Sangatana, Mazdoor Kisan Shakti Sangatana, whose hard work is lauded by one and all. This paper will try and deal with those provisions of this landmark law which either prevent the information from being received by the seeker and also attempt to analyze the so-called hurdles existing in this process by studying the other provisions of Indian laws. Two parts are there in RTI Act. For the first part deals with the exemptions from disclosure of information as per section 8, 9, 24 of RTI Act 2005, and the second part will make a assessment of the provisions of certain colonial laws such as Official Secrets Act and Civil Services Code of Conduct rules with respect to its incompatibility with RTI Act 2005. Section 8 of RTI Act 2005 says exemptions from disclosure of information. Notwithstanding anything contained in this Act, there shall be no obligation to give any citizen information disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific, or economic interests of the state, relation with foreign state, or lead to incitement of an offence. Information which has been expressly forbidden to be published by any court of law or tribunal or disclosure of which may constitute contempt of court. Information disclosure of which would cause breach of privilege of parliament and state legislature. Information including commercial confidence, trade secrets, intellectual property, the disclosure of which would harm the competitive position of a third party unless the competent authority is satisfied that larger public interest warrants the disclosure of such information. Information available to a person in his fiduciary relationship unless the competent authority is satisfied that the larger public interest warrants the disclosure of such information. Information received in confidence from foreign government. The disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence for law enforcement or security purpose. Information which would impede the process of investigation or apprehension or prosecution of offenders. The cabinet papers, including records of deliberations of the Council of Ministers, Secretaries, and other officers, provided that the decisions of Council of Ministers, the reasons thereof, and the material on the basis of which the decisions were taken shall be made public after the decisions has been taken and the matter is complete or over, provided that those matters which come under the exemptions specified in this section shall not be disclosed. The information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause an unwarranted invasion of the privacy of the individual unless the Central Public Information Officer or State Public Information Officer or the appellate authority or the case may be is satisfied that the larger public interest justifies the disclosure of such information, provided that the information which cannot be denied to the parliament or a state legislature shall not be denied to any person, notwithstanding anything in the Official Secrets Act 1923 nor any of the exceptions provided permissible in accordance with the subsection 1. A public authority may allow access to information if public interest in disclosure outweighs the harm to the protected interests. Coming to permissible exceptions, the competent authority is satisfied that large public interest warrants the disclosure of such information, then it is permitted. The decisions of the Council of Ministers, the reasons thereof, and the material on the basis of which the decisions were taken shall be made public after the decision has been taken and the matter is complete or over. Information which cannot be denied to the Parliament or state legislature shall not be denied to any person. Lapse of for 20 years. Any information occurred or happened 20 years before the date on which any request is made shall be provided. Decision of the central government shall be final on the question as to the date from which the said period of 20 years has to be computed, subject to usual appeals provided for in RTA Act. Case law. Bhagwal Seth versus Bank of Baroda decided on 12th January 2001. CIC, that is Central Information Commission, observed that apart from commercial confidence, there is also a fiduciary relationship between the banks and the customers. So, before providing the information, the bank has to check the public interest. In this case, the bank refuses to provide information as if the bank will provide, it will lead to the breach of trust and may also harm the party as the competitiveness position of the third party. The next case is Arvind Kejriwal versus Central Public Information Officer. A coordinate bench of Supreme Court has held that the service record of a government employee contained in the DPC minutes or SAR is personal to such officer and that such information can be provided to the third party only after giving a finding as regards the larger public interest involved. Pinky Gandrewal versus Union Public Service Commission. The facts in this case that information was sought by the petitioner about the selection list of 11 deputy director of mines safety by Service Commission. The information was released with the seniority cum merit list, but the personal information of selected candidates was rejected on the grounds of exemption provisions under Section 8. The judgment, the court held that the commission had committed error in ordering the Service Commission to not provide the information as requested. It held that the information sought after is necessary for the larger public interest and therefore the request and the release does not come under Section 8. Coming to the next topic, legal regulation of advertising in India referring to important laws. Advertising are fundamentally a commercial speech which the Supreme Court has held is a part of freedom of speech and expression, fundamental right under Article 19(1)(a) of the Constitution of India. Advertising is one of the means of mass communication along with other means of publicity, sales, promotion. Advertising presents the most pervasive possible selling at the lowest cost, which means it is actually a promotional message and a selling idea. However, with the increasing misuse, forced the government to pass several laws to keep in check such sort of advertisements. Laws on advertising. The several legislations that are responsible for controlling misleading advertisements are Press Council of India Act 1978, Cable Television Regulation Act 1955, and Cable Television Amendment Act 2006. Establishment of ASCI, that is Advertisement Standard Council of India 1985. The Department of Commissioner of Affairs also maintain an online portal where consumers can post their grievances against misleading advertisements. The Advertising Standard Council of India ASCI, it was established as a non-statutory tribunal. It created a self-regulated mechanism of introducing the advertising ethics in India. The ASCI judges the advertisements based upon its code of advertising practice, also known as ASCI code. This code applies to advertisements read, heard, or viewed in India, even if they originate or are published abroad, so long as they are directed to consumers in India or are exposed to a significant number of consumers in India. The laws and act governing advertisements. The advertising in India has seen the vast transformation from the Doordarshan and Prasar Bharati way of advertising to the modern television channel and media. However, with increasing misuse such as promoting a public prohibited medicine, promotion of alcohol, forced the government to pass several laws to keep in check such advertisement. Legislation that are responsible for controlling misleading advertisements are Consumer Protection Act 1986 and Advertising, Cable Television Regulation Act 1995, Cable Television Amendment Act 2006. Restriction on advertising under Cigarette and Tobacco Act 2003, advertising regulations under Drug and Magic Remedies Act 1954 and Drugs and Cosmetic Act 1940, advertising restrictions under Prenatal Diagnostic Techniques, Regulation and Prevention of Misuse Act 1994, Young Person Harmful Publication Act 1956, Indian Penal Code and Criminality of Advertisement, Transplantation of Human Organ Act 1994. Landmark cases: the Common Cause versus Union of India. The writ petition, it is a petition civil case number 13 2003, passed on 15th May 2015. This case is regarding the regulation of government advertisements to ensure that no public funds are being misused and to curb the wastage of these funds which are used to glorify specific individuals. Samir Jain and others versus Union of India and others. The case has been filed to address the issue faced by the petitioner, which was pertaining to the excessive powers given to the ASCI, that is Advertising Standard Council of India. It has been submitted that ASCI, being a private body, has been given the whole authority to regulate the misleading and false advertisements from being published. The petitioner claims that such powers must be vested in the government, in the hands of government. Salient features of Prasar Bharati Act, that is Prasar Bharati. Introduction. Media is a mediator of information between the citizens and the state. It is the fourth pillar of our democracy, which has a responsibility in shaping the public opinion. A vibrant and free media is to be necessary for a healthy democracy. Any country which has aspired to democratic norms of governance should have a free and fair press. The Prasar Bharati Act provides for the establishment of a broadcasting corporation to be known as Prasar Bharati and define its composition, function, and powers. The Act grants autonomy to All India Radio and to the Doordarshan, both of which were previously under government control. The Act received the assent of the President of India on 12th September 1990 after being unanimously passed by Parliament. It was finally implemented on November 1997. Objectives of the Act. The twin objectives of Prasar Bharati Act of 1990 are crystallized in Section 12 of law. Section 12(3)(a) mandates that Prasar Bharati ensure that broadcasting is conducted as a public service. Section 12(3)(b) reinforces that the purpose of establishing the corporation is to gather news, not propaganda. The Act came into existence after the decades of post-independence struggle to free broadcasting from the stronghold of the government. Coming to the history on Prasar Bharati, the efforts of an autonomous broadcasting corporation can be traced to the post-emergency BG Varghese Committee, which recommended the formation of Akash Bharati, or the National Broadcast Trust for All India Radio and Doordarshan. In 1979, Information and Broadcasting Minister L.K. Advani proposed a bill for an autonomous corporation called Prasar Bharati for AIR and Doordarshan. In 1989, Prasar Bharati Bill was introduced by the National Front government. Bill borrowed some contents from the previous bill and also added some new changes. VP Singh government moved this bill and was passed in Lok Sabha in August 1990. Finally, the Prasar Bharati came into force in 1997, which is established under the Prasar Bharati Act and came into existence on 23rd November 1997. Salient features of the Act: to provide the autonomy of Akashvani and Doordarshan so that to ensure the function in a fair, objective and creative manner, to uphold the unity and integrity of the country, to maintain the democratic and social values which are enshrined in the Constitution, to look after the safeguarding of the citizens' right to be informed freely, truthfully and objectively, to spread literacy, agriculture, rural development, health, family welfare, environment, science and technology, to encourage healthy competition and spirit of sportsmanship by providing adequate coverage to sports and games, to promote cultures and languages of the various regions of broadcasting many programs, to provide special needs of the youth, always organize special programs, to remove the problems of women, pay special attention to the upliftment of the women, to take special steps for the protection of the children, the aged, the blind and handicapped, and other vulnerable sections, to protect the rights of working classes and advancing their welfare, to provide the suitable programs for the needs of the minorities and tribal communities, to promote national integration that will maintain the community language of the nation, to promote research and development activities of radio broadcast and television broadcast technology. Case laws. PCCI Nimbus Prasar Bharati case. According to the court, the objects and purpose of the Sports Act are to provide access to the largest number of the viewer through sports broadcasting channels with Prasar Bharati. Court also said that it should be essentially directed towards those citizens who do not have access to cable television and only access to terrestrial and DTH networks of Prasar Bharati. Court also pointed out the virtue of Section 12, Class 3, Subclass C of Prasar Bharati Act. Union of India versus Board of Control for Cricket in India and others. The Supreme Court held that Prasar Bharati cannot engage in free transmission of the signals of live sporting or cricketing events received from content right holders or owners to cable operators. Thank you. Please like, share, subscribe, and comment.